One of the benefits of living in a democratic country with a well-established judicial system is the opportunity to use the courts to achieve justice and set wrongs right. But there is a drawback. Some people go to court about things that make most of us shake our heads. Hello friends and welcome another YouTube video. Please hit the subscribe button to support what we do. For many Americans, joblessness is an unfortunate but unavoidable side effect of a bad economy. In 2009, Trina Thompson from New York blamed her unemployment on the school she attended. She sued Monroe College for $72,000 when she was unable to find a job 3 months after graduating with a bachelor's degree in information technology. She specifically blamed the Office of Career Advancement in the college for not trying hard enough to place her in a job after graduation, despite her attendance record and her 2.7 grade point average. According to the lawsuit filed, Trina Thompson sought to recoup the $70,000 that she spent in tuition plus additional $2,000 for the stress of her job search. Most of the people might be honored to resemble a famous athlete, but that's not the case with Alan Heckard. This man from Portland said he had been mistaken for basketball legend Michael Jordan almost every day for 15 years and he was sick and tired of it. In 2006, he sued the former Chicago Bull player along with Nike co-founder Phil Knight that was promoting for a combined $832 million, claiming personal injury and emotional pain and suffering. Alan Heckard, an African American with a shaved head and an earring in his left ear, did look a little like Jordan, but he was also 6 inches shorter and 8 years older than his more famous counterpart. Heckard dropped this hilarious, but true court case when he realized he had no reasonable explanation for the $832 million he was suing for. In 2007, when Custom Cleaners, a neighborhood dry cleaner, returned what Judge Roy Pearson claimed to be the wrong pair of pants. Pearson, an administrative law judge, decided to take action and sue for $67 million. He claimed that the pants he dropped off for alteration had been lost and the dry cleaner did not meet the claim of the "satisfaction guaranteed" sign that hung in the dry cleaner's window. The $67 million, which later was lowered to $53 million, Pearson says was equal to claims for common law fraud violations. Pearson eventually lost the pant case after he failed to prove the trousers he picked up were not his. In 1999, Daniel Dukes tragically died while trying to achieve his lifelong dream of swimming with a whale. He hid himself from the SeaWorld security guards and was killed by an orca whale after the park closed. Daniel's parents filed a multi-million-dollar lawsuit against SeaWorld for failure to display public signs warning of the dangers which whales can cause to humans. The suit was quietly dropped later with no explanation for the family's change of heart. What happens when we put all our trust in a weather prediction? A bad day evidently. An Israeli woman sued a TV station when the weatherman wrongly predicted a nice day. The woman ended up getting caught in the rain, causing her to catch the flu, miss a week of work, and purchase medication. She sued for $1,000, claiming that the incident caused her stress, and won the hilarious but true court case. Let's go back in history a bit. In 1893, the Supreme Court ruled that the tomato is a vegetable. The whole situation came about during a case between the Nix family, one of the largest sellers of produce in New York City, and Edward Hedden, a collector at the Port of New York. The Nix family sued Hedden to recover fees they had spent on transporting the tomatoes, because legislation at the time stated tax must be paid on imported vegetables, but not fruit. Allegedly during the trial, both sides put forward definitions of fruit and vegetables to argue their cases. Botanically, any seed-bearing structure formed from a flowering plant is a fruit. The court unanimously decided that the scientific classification doesn't change common language, and that a tomato is a vegetable because the public generally think of it as one. On February 27, 1992, Stella Liebeck ordered a 49-cent cup of coffee from a McDonald's drive-thru. She was in the passenger's seat of her grandson's car, which did not have cup holders. In the process of trying to add cream and sugar, Liebeck put the coffee between her knees and pulled the far side of the lid to remove it but accidentally spilled the entire cup. As she was wearing cotton trousers, they absorbed the coffee and fused to her skin, causing third-degree burns. After 8 days in hospital and undergoing skin grafting, Liebeck lost 20 pounds and needed extra care for 3 weeks. She was left partially disabled for the next 2 years. Liebeck sought to receive $20,000 from McDonald's to cover her medical expenses, but they only offered $800. She then filed a lawsuit against the chain, accusing them of gross negligence for selling coffee that was defectively manufactured and unreasonably dangerous. After 2 more attempts to settle, and McDonald's refusing twice, the case went to trial. During the hearings, it was revealed that the chain had received more than 700 reports of people being burned by their coffee. The jury found McDonald's was 80% responsible for the incident and awarded Liebeck $200,000 in compensatory damages. She also received $2.7 million in punitive damages, calculated by the jurors as 2 days' worth of coffee sales for McDonald's. This was our list of most bizarre court cases. If you enjoy our video, please hit like and subscribe button and support our work. Thank you.